Well, here in the studios, Afam Osigwe, who is a senior advocate of Nigeria, joins us now to shed light on this and the court decision yesterday. Good morning. Thank you for coming on today.
Good morning, Chamberlain. Morning,
Good morning.
Well, clearly this follows that decision from yesterday that the court granted both INEC and the parties to inspect materials in INEC configure, but make sure it's on the back end so everybody can access, as INEC has included in their as the reasons for this shedding of the election. So, considering all that is playing out, what do you think of this?
Well, you all know that the INEC went to court in the first place to say, look, the order of court prevents us from tampering with the BVAs used for the election, but we need to reconfigure it. And then the Labour Party, I understand, opposed the application on the ground that the data for that the BVAs is the primary register of voters, which will show how many voters were created, how many people voted at that election. And so that allowing INEC to reconfigure it will mean that the data will be lost. But INEC countered by saying, no, the data will not be lost, it will be backed up. And all the information will be accessible just like Chamberlain read. So, and they indicated to the court too that failure to allow INEC to reconfigure the BVAs will mean that the INEC will be unable to conduct the remaining gubernatorial and House of Assembly elections. And the court agreed with them that with the assurance they've given, the Labour Party not filing any affidavit to counter the fact that they need to do it, that data will not be tampered with or lost, that there was no basis for not granting it. And the court did not want to tie INEC's hands, so the court granted it. And maybe because, not maybe because the order came late in the day yesterday, and they had to reconfigure 176,000 BVAs to be used for the election. This occasioned the postponement in the election scheduled to take place on Saturday. So the whole essence of this is about evidence required for use in the election petition tribunal. While those who are petitioners have doubts about the integrity of INEC in not tampering with this, INEC, on its honor, gave assurance that it could be trusted that this cannot be tampered with, and that they will have full access to all the back-end data relating to this. And I'm sure if anybody tampered with such things, forensically this can also be discovered. So the whole essence of it is to ensure that the remaining elections take place, and also to ensure that the evidence that may be required by those who go to court are not tampered with, and are stored in such a manner that they will be able to retrieve them without disrupting the electoral process. I
know that technical people raise different issues, but this clearly is also within the legal time frame within which the elections can be conducted. Absolutely. So there's no cause for any concerns in this particular area. Not to my mind.
Well, I do know that, yesterday's judgment was going to hold, we were already told by analysts that it was going to have, consequences whichever way. INEC has raised a few issues here and in its statement, but what also comes to mind is how we put this in mind when we thought about the introduction of technology into our elections. There are questions as to whether or not this was thought about. In the Osun elections, or even in almost all the elections that have been conducted with the BVAs, I think only the Osun elections have gone to court. And we've seen that in the conduct of that election petition tribunal, evidence was required from the BVAs, and the BVAs was, in fact, I think we understand, demanded by the tribunal to be brought there. So there are questions as to whether we have thought about the implications of the introduction of technology. Do you have any idea of how it worked with the smart card reader, and whether there was anything we could have learned from that?
Now, with the smart card reader, one can't really say, because of the Supreme Court judgment in the, I think, Lagos and Rivers State matter, where the court held that the data from the smart card reader could not be relied on for determining the number of accredited voters, because it was not part of the law then, and it was a mere regulation by INEC. But now, under the 2022 Electoral Act, INEC was empowered to determine how to conduct the election, unlike in 2010 Act, where electronic mode of voting accreditation was outright forbidden by the Act. So the introduction of technology always comes with the downside, always comes with the suspicion. Even in the US, people like Trump are still casting doubt about the integrity of the electoral process that produced Joe Biden as president. So there will always be people who suspect that somebody somewhere may impute data or corrupt data or hack into the system to give a different reading. And it is not out of place for those who are challenging an election which they believe was conducted without substantial compliance with the law, without substantial compliance with the guidelines made by the electoral body, not to trust that same body, not to tamper with the data, because they intend to impeach the declared results. So you would expect them not to say, look, he said, well, say, we don't trust you. We don't trust you not to tamper with evidence. So it's a way of, all in all, is to find a middle ground which satisfies everybody, which allows INEC to carry out its job, and which also preserves the evidence in the form it is, so that they will be used in such a manner that nobody will have doubts about it. You mentioned the Osun election, gubernatorial election.
Yes.
The problem with that election, to my understanding, was that INEC certified different results of the product of the BVAs, thereby casting doubt as to
the report.
The report.
That was produced.
What do we believe? At what point does the BVAs preserve the correct record? Is it automatic? Does it take forever? Can it keep reproducing different outcome?
Even though there were arguments saying that they presented that the ones that they gave to different political parties were the ones that were coming in at the time. So both of them were different, and it wasn't the final output. And they expected the court to have take a look at the BVAs machine itself. That's just...
So Chamberlain, if you ask me, that's where the problem is. If you can generate different results from the same thing at different times, different people.
No, not when it's concluded.
Now, my understanding of BVAs is that it works online and offline. So when you are connected to network, it's automatic. So how long did it take for those other ones to connect to the network?
Okay.
To keep giving different... I'm not a technical person,
yeah,
but
so.
that you understand why people from the Osun election, and because of that, the tribunal found that there was overvoting and now cancelled results from certain areas and upturned the result declared by INEC. So there's already an integrity issue concerning the output from BVAs. And so when people have doubts as to whether the backing of it in the course of the reconfiguration would affect the output, it's not after all baseless.
I think it's just important to also state that in that particular election, I think INEC is part of the appeal now. It's part of the appeal process. They said that there was an interim report and then there was a final report. And it was the final report that they were hoping the tribunal will rely on. But what I'm trying to say is that it doesn't look like we've given sufficient room. We know that traditionally, for presidential and governorship elections, we will hold the presidential first. I mean, whichever one we decide. I know there's still controversy as to which one to hold first. But our recent experience has shown that we will hold the presidential elections first, and 2 weeks after, we will conduct the governorship elections. I'm just asking that with the introduction of technology, especially now that it is recognized by the Electoral Act, where it says that INEC will, a voter will be accredited using a smart card reader or any other electronic device, which INEC decides. I'm just wondering whether we have given sufficient room in that 2 weeks for, to take cognizance of whatever litigation could arise as a result of the use of technology.
Well, this is a first-time experience, and I'm sure as we move forward, INEC will devise ways to accommodate such developments, and the court have also shown their willingness to take these applications and rule on them as quickly as possible so as not to disrupt the entire process. So it's a learning process.
Now, let me ask you quickly.
Yeah, if I could just follow up on that one.
Okay,
look at this. He says that it has come far too late for the reconfiguration to be concluded. So some could interpret this as though the court could have done it a little faster.
Well, I have my doubts. INEC declared the winner of the election around 2 a.m. on Monday nights. That's in the dawn of Tuesday. And people went to court immediately to request to be given access to this. I think they got the order on Thursday. And INEC came back immediately, the day after they got the order, if I'm not mistaken, to ask that the order be varied to allow them to reconfigure. And the other people had to be put on notice, and they had to file things. And the court ruled on Wednesday. So if you look at the circumstances, it would not appear to have come too late. But maybe, too, the court could have sat over the weekend and taken all arguments in this, maybe ruled. Maybe that's also what we may need to consider, that the weekends should not be wasted in this kind of situation, so that decisions will be rendered in good time to allow INEC to make the requisite preparations for the election. And also INEC, immediately upon being served an order, should be up and doing to request that certain things be done so as not to tie its hands.
Because we don't know how long it takes to configure the BVAs.
Well, I don't know.
Yeah, that's part of what we're saying. Look, we could have possibly get across so INEC and ask this question, see if they make themselves available. And then others also wonder, could it also be that maybe the commission thinks, look, weekend is best time for this kind of elections, and so we cannot do it weekday. So even if we finish configuration on, say, a Tuesday or Wednesday, we may not be able to do elections on a Thursday, so we push it to Saturday. Who knows? Just maybe.
I'm just a little curious as to, for a moment, the question skipped my head, but I'm just a little curious as to whether our courts, because right now it does appear, even though, from the many applications that were made, it does appear that the court, has tried its best to be fair to all. INEC asked for a variation. They didn't quite grant that variation. I don't know what the details of the variation or what that might mean in terms of asking for a variation, but they allowed INEC reconfigure the BVAs.
Which was essentially what INEC wanted.
Yes, which is
to permit it
to reconfigure the BVAs. And I'm just wondering as well, because they had to go with INEC's word that the data indeed has been backed up. And that the litigants will have access to the data in its back-end server. But I am just wondering, do you think that our courts, with the more we introduce technology into our electoral matters, do you think that our courts are, will I say, enabled to understand just how technology will now begin to affect things that have to do with law? Would they need expert opinion, for instance, etc.?
Naturally. All parties to this suit will be bringing a lot of expert witnesses, forensic experts especially, and the court will be able to find its way through them because that's why they are learned people. That's why they are knowledgeable in all aspects of life and the law. And so while it may be a novel issue that was going to play out in the course of these election petitions, the courts, the judges that will man this tribunal will also on their own be reading up, apprising themselves of the development in that area of law, and also listening intently to the evidence of different expert witnesses that may be called, and then deciding who to believe and who not to believe. They are not superhuman, by the way, but then again, they are intelligent enough to know which evidence is credible and which they would believe, despite them not being technical persons.
Let's quickly take this conversation now to our colleagues in Lagos.
Well, thanks, Mark. Let me just bring in this angle to it. It's very interesting what is unfolding before our very eyes. But I'd like to know, in the process of justice or getting justice, which is weightier? Is it justice for one or a party or the greater good? And I'll give you an example using this scenario now. So we have the Labour Party or the PDP saying, well, INEC should not be allowed to tamper with the BVAs. And INEC is thinking, well, there is a big election coming up, the state and the state assembly, like the governorship and state assembly elections coming up. And I know a lot of people were divided. Do we allow, to allow justice in court or the process of justice, allow those parties be able to inspect the BVAs for as long as it will take? Mind you, that would mean that the governorship and state assembly elections will be postponed indefinitely, perhaps up until they're done with the inspection. And others were saying, well, we need to go ahead with this election. So really, in the process of justice, which is weightier, what are the considerations being made? Because some might say that, well, this is not exactly justice in court, or this harms the process of justice, while others think, well, the common good is bigger here.
Justice sometimes is about finding what works, what is fair and just in the circumstance. It may not sometimes be for one person, it may not always be for the greater good, but it depends on facts and circumstance of the case. And because when you talk about greater good, sometimes it may be when you pander to what you consider an ideal. So an ideal may not always be the case because the facts may not support the ideal, so the ideal will not be opposite. Now, in this case, the Constitution has limited a time within which INEC must conduct election. And INEC cannot conduct the election out of that time. So it's not a situation where you can say, until they finish the inspection, hold on with the election. And then that's one. But in this case, the tribunal, Election Petition Tribunal, believed the evidence of INEC that it would not tamper with the data stored on the BVAs. The court believed INEC that this data will be backed up in their server and will not be tampered with. And that's the decision of the court. Not everybody will like it. Most decisions of court will leave some people happy, some people unhappy. And this may be the kind of situation, maybe that kind of situation. But the point is, the court works based on facts. It makes decisions based on facts available to it. And I read in the media, though, one of the justices, in the ruling, the court saying that the Labour Party did not counter a particular thing said by INEC about the mode of storing it or some other thing about that, and the effect it would have on the gubernatorial and House of Assembly elections. And so that's what the court believed. And it would not be good, too, to have an unending inspection that will disrupt the electoral process. So the court, having taken the assurance by INEC that nothing will be tampered with, seemed to have believed that even though the primary entry point, or where this data is imputed, is in the BVAs is so is such that it uploads this data to a server. Right. So which means that just like a document typed in your computer, which can also be backed up in a server. Right. So even when that document is deleted from your system, it is available in some other place in the same form in which it was produced. Right. I'm not much of a technical person concerning this.
Mr. Sigwe, let me rescue you here.
But that's what the court has ruled at the moment, and that is the position of the law.
Right, let me rescue you. A lot of us have had to become emergency techies overnight just to understand this. But quickly now, some would also say that perhaps INEC brought this upon itself, because I think it rises and falls on that question of trust. How much do these parties trust INEC? And that's sad, because, I mean, INEC, if anybody should have the highest trust coefficient in Nigeria, should be INEC. So INEC has perhaps a week and more to rebuild that trust. What do you think INEC should begin to do as a matter of urgency now to rebuild the trust? Because we still expect to have INEC after this election for the conduct of future elections.
You know, INEC must always act in a manner that shows its independence and neutrality. Neutrality especially. INEC must act in a manner that when INEC says, we will do this, people should be away believing that INEC can take INEC's word to the bank. So when INEC says, this is a guideline we have issued, we are going to conduct an election in strict compliance with this, and then INEC fails to do that, the trust issue will always be there. But when INEC says, these are guidelines, we will follow it religiously, results will be done, this is how we are going to conduct the election materials will be there by 8 a.m., and then election materials are there, the officials are there. But then INEC says we are going to be there, and no electoral official shows up. And the electoral officials who show up are able to identify the polling units, and the reverse works, and the results are transmitted in the manner provided in the guidelines. And INEC is seen not to have a dog in the fight. And INEC, whatever result declared by INEC, reflects the results as declared at the polling units. Then people will trust it. But if it is otherwise, and if there are grounds to doubt that INEC is acting in accordance with the will of the people, or like in good faith with guidelines, then these trust issues will always be there.
Ms. Osigwe, for me, I'm wondering if INEC is learning a little too slowly lessons from the conduct of elections using, electronic devices such as the BVAs, because following the announcement of the postponement of the governorship elections due to that Presidential Election Tribunal ruling, some officials who speak on condition of anonymity are saying that the commission will need to move the BVAS machines to the headquarters for reconfiguring. So as INEC learned a little too slowly, I say this again because, in past elections, presidential candidates had gone to court. So there was that very real possibility that election losers will go to court.
I didn't quite get your question, please.
In this whole process, you said earlier when Malcolm was asking you about, you know, the implications of using the digital device to conduct elections, that what are the lessons that have been learned? So, and you say that it's a learning curve. So for me, as INEC learned a little too slowly, shouldn't it have anticipated that election losers will go to court because of the implications of using, you know, the digital device to conduct elections?
I think people are not going to court because they are using an electronic device. People are going to court because they question INEC's good faith to its guidelines. They have doubts about whether the results declared reflect what they believe was the outcome of the voting in the polling units. So it's not about the electronic device. It could also happen if it was just paper-based election. It's all about trust. It's all about people going away feeling that they lost fair and square. But when people go away feeling that,
it's not
I
about,
actually won, or somebody stole the match on me.
Sorry to come in there. It's not about people going. It's not about people going to court here. It's about INEC's preparation. Did it anticipate enough that people would go to court, and shouldn't it have prepared, perhaps additional BVAS machines for, this possibility for where we find ourselves now?
Well, your question suggests that shouldn't INEC have prepared for another set of 176,000 BVAS machines? And that would have been killing for our economy. I mean, know that the budget we've been operating a budget deficit, we're borrowing to fund our budget, and so much money has gone to funding INEC for the preparation of this election. And I do not think the outcome has reflected the huge funds spent on it. But to suggest that they should have two sets also may mean having a lot of BVAS that may fall into the wrong hands. And, but I think using the same for the election is not bad, but INEC seemed to be ill-prepared or somehow scuttled its own internal processes. I may never be able to know the right answer, but INEC has not showed that it was prepared for all likely things that may come out of this election, and the manner they conducted the election did not leave people satisfied. Let people scratching their heads that indeed INEC performed below par.
Point taking about the costs, but what lessons have we now learned, about this process for future presidential elections, given the fact that we are a people prone to litigation, particularly after having lost elections?
We are people prone to litigation after losing an election, not because not because people are sore losers, but people go away believing that the process was not fair and transparent. People go away believing that if they are in compliance with the provisions of the law and the procedure for election, probably they will not have lost. When you have voter intimidation, violence, results mutilated, results uploaded being different from what is declared in some cases, or people being forced under duress to declare a person who may not have won an election as the winner, then people will go to court. But if people see that the law were won and all results have passed the integrity test, I don't think many people will go to court. There will be less time spent on court. Look at party primaries. More people went to court last year because most of the party primaries were a huge joke. And that put a lot of pressure on the Federal High Court, which now moved on to the Court of Appeal and the Supreme Court. Until our processes are right, until politicians learn to respect the rule of law, act in accordance with provisions of their own constitutions and guidelines for the conduct of primaries, people will always go to court. And also until INEC and the participants in the electoral process allow the will of the people to prevail. Do not destroy ballot boxes. Do not use violence to prevent people from voting. Do not maim and kill people. Do not force people or induce electoral officials to do the wrong thing. Do not mutilate the result. People will go to court.
Okay, just one more quick one before we go. Is there any definition, or what can it be, or what's your thought about the question of substantial compliance? In this case now, 176,000 BVAS. So what can possibly be this scenario?
It's a matter of fact for the court to decide. No lawyer, no person can sit down and tell you that his own definition of what is substantial compliance is the right one. But I would like to believe that the court will always, like we say, look at, would the ordinary man in Shigwe believing that the right thing has been done? Has INEC done? So it has to be a catalog of violations of the law, failure to comply with guidelines, comply with the provisions of the law, and then the pattern of how the whole thing played out. And then the court will make a decision one way or the other. But I will be unable to give you a definition that satisfies you or any person.
Yeah, because whatever you give, several people
it's arguable.
No, I don't agree,
I don't agree with
one.
you. Yeah.
Well, we'll just thank you for coming on. Alpha Mosigwe is a senior advocate of Nigeria. Always a pleasure to have you on.
Thank you, Chamberlain.
All right, we will be back in just a moment. Stay with us.